First case this morning is State v. Rankin. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Do you know how long you'd like to reserve?
I'd like to reserve 5 minutes.
Okay, very good. As you'll note, that'll be up there. Try to pay attention to the top one. When it gets down to 5, that's when your time is up at that point in time. It doesn't cycle to show just 10 minutes. Arguments are being recorded. When you present your argument, please make sure you introduce yourself. Keep your voice up and remain behind the podium for our recording purposes. You should not refer to the name of any children, minor, or victim during the case, and you can refer to them by initials or terms like the child if we happen to come up in this case. I don't know that would based upon the procedural thing we're talking about today. The judge has read your briefs and are ready to proceed whenever you.
Thank you, Judge. Good morning. May it please the court, my name is Rick Raley. I'm appearing today on behalf of the appellant in this case, I can't even pronounce it, the state of Ohio. I'm here to ask that this court reverse the trial court's order that excluded certain scientific evidence as a discovery sanction. The evidence was called a cyber check report, which is prepared by a private company called Global Intelligence. The defendant in this case, Mr. Rankin, requested that the state produce Global Intelligence proprietary source code and algorithms. The state responded that it was not within the state's possession and it could not comply with that request. They had to go to Global Intelligence. Despite the fact that it was not in the state's possession, the trial court still ordered the state to produce it, and when it could not, it decided to exclude the evidence without considering any alternative sanctions. So the state presents to you one sole assignment of error for review, and that's the trial court abused its discretion by excluding this evidence. And there are three reasons that I outlined in my brief. I believe any of them are independently sufficient to reverse the trial court's judgment. And I do want to focus on the first reason that I put in that brief, and I would like to address mostly today, and that is the trial court's order exceeds the scope of Rule 16b. That requires the state to only produce items that are within the possession of the state or reasonably available to it. There's no evidence that it's within the state's possession. It could not produce this information. I will briefly summarize that even if we were to look past that issue, there's no indication that the trial judge considered the Lakewood factors or at least severe alternative sanctions besides exclusion of the evidence. There's no indication that she considered any of those alternatives, so for that reason it could also go back. Finally, and I think this is also outlined in the brief, the trial judge considered the credibility of this evidence, the reliability of the evidence, despite the fact there wasn't a Dahlgren hearing. In fact, explicitly when the state asked, are we doing a Dahlgren hearing today, the trial judge said, no, we're not. And on top of that, the trial judge compounded the error by also doing her own Google search results that she put into her judgment entry, which colored her analysis of this issue. I do want to start out with just some basics about CyberCheck. I don't want to get into the depths of the technology because it's not really in the record, and there has been a Dahlgren hearing. But essentially, as part of pretrial discovery, the state received and produced a CyberCheck report. It indicated that Mr. Rankin's cyber profile was located near the location of the murder scene that's involved in this case. In the Mahdi case and the Black case that this court recently addressed, the same technology was offered at trial without objection. CyberCheck reports are produced by Global Intelligence. It's a company that's based in Canada. There's also a office here in America. I believe it's in Indiana. There's a process of creating a report that starts with a police agency sending an ask that says, we want to see this particular person's profile, is at this location at this time. CyberCheck then uses a proprietary cyber DNA engine to scour the internet, an open source data, which essentially is my understanding that our telephone here has a bunch of apps on it, and those apps make constant attempts to connect to Wi-Fi portals and and leaves data trails wherever you were going. And this proprietary algorithm can gather that information and put it into a report about a location. The Akron Police Department had a contract with Global Intelligence for these reports. This ask was presented in accordance with that contract. The report came back. So Mr. Rankin has now asked for Global Intelligence proprietary information. And this is where we go into this first reason for why I think the trial court got it wrong here. And that is, the state just doesn't have that information. It's not something we can provide. If it was within the states, if it was in our office right now, they'd have it. The fact of the matter is that's not the case. State versus Rivas, the Ohio Supreme Court says the state only can produce items that are tangible evidence in its possession. There's all kinds of cases about if it's a victim's medical records held by a hospital, that can't be produced by the state. The state can't offer access to a victim's home because it's not in the state's possession.
Counsel, well, I was wondering when I was reading the briefs in regard to your argument, maybe that is the remedy then, you exclude the evidence if they're not able to ascertain, the information they need in order to contest the reliability, the admission of the evidence.
Now, Judge, I would say that on that point, it is the state's burden to prove reliability. And they could cross-examine at that Daubert hearing all the things that are included in this brief from the defense and in the filings in the trial court. Those are all fair game, and they could certainly say all these things about we can't reproduce, we don't know this, we don't know that, how do you get that? And if the judge decides based on that they can't determine reliability, it's excluded. If it was a situation where there was a subpoena to global intelligence and global intelligence failed to comply with that subpoena, then I think there'd also be a separate question we'd be having here today. But Mr. Rankin did not avail himself of that procedure. He knew that the state didn't have it, and yet he sought it from the state. That's getting an end around Daubert by saying, you know what, I'm going to get this excluded by asking this guy even though the other guy has it. That's not what the criminal rules are really intended to create. That's why we have a rule that allows third-party subpoenas. If that procedure had been followed first, we may not be here. And I think that
But he did testify he wasn't turning it over, though, right?
He did testify that. However, there was not an order for him to turn it over. There was not a subpoena directed towards him. So I think that him saying that in a case without any repercussions for his not following a court order is not something we should really be speculating about right now. I would also cite in my reply brief about the toxolizer cases. I cite the North Dakota Levine case. There's also federal court cases about other technology. If source code is held by a private company, that private company is the only people that possess it. They're the ones who disclose it. So I really do think at this point, these credibility discussions about Mr. Mosher, about cyber check liability, those are all red herrings at this point in this procedure. That would be all coming up when it comes towards a Daubert hearing. I'd also
So
say...
you're saying that, are you arguing that really all these issues may or may not have been resolved if there was a Daubert hearing?
I believe there's a Daubert hearing, they would have all been resolved, correct.
Counsel, what about the part in Criminal Rule 16 about whether the state's in possession or reasonably, if what's being asked for is reasonably available to it?
So I think that actually that testimony from Mr. Mosher shows that it's not reasonably available to the state. When he was asked in this court on whether he would give it over, he said no. So that's not reasonably available to the state. If there was something offered about a contract where the contract allows us to get this information, then that would be different, but that's not offered into the record. So I don't believe it's reasonably available to just say, well, since you know where it is, you can get it. That would be contrary, and that would be pretty much that would be an exception that swallows the rule, I'd say.
Well, did the state subpoena Mosher for that information after the request for discovery made upon the state?
No, but it's really on the defendant. The defendant's looking for the information that's on them to ask that. It might be something that the state would want to do when they're having a Daubert hearing to prove the reliability, but we haven't gotten to that point because this motion to compel was filed early June, there was a hearing mid-June, and it gets excluded a week later. So that's not where we are in these proceedings. I'd also respond briefly to the argument that global intelligence is somehow a governmental agency by the mere fact there's a contract. I think under principles of contract law, agency theory, that just isn't the case. The receipt of public funding does not transform global intelligence into a governmental actor like DCI.
Doesn't that perhaps make it somewhat more clear that you have reasonable access to it, as opposed to you talk about a victim and their hospital records. You have no contract with the hospital. Here you have a contract with this party, and could say to your party, you have a contract with, you need to provide this, and you have it.
So the contract's not in the record. I can't tell you that the contract says anything about whether we can get proprietary information, and I don't know that right now, as I said, I've never seen the contract.
You have 1 minute left, Mr. Rankin, just so you know.
Thank you. I do want to say that if we go into the severity of the sanctions, I do think a continuance for a subpoena was the more appropriate route in this route if we decide that there is a violation. That would have allowed some of these issues we're talking about now to be fleshed out. However, that was not the procedure that was used, and I think that's another grounds for reversal. So if there aren't any further questions now, I would save for rebuttal.
Seeing no questions, thank you, Mr. Rankin. You have your full time for rebuttal.
Good morning, Your Honors. Attorney Don Malarczyk here on behalf of the appellee, Javion Rankin. I wanted to talk a little bit about the technology itself and then get into the substance of some of the issues Mr. Rayleigh has raised. So what we know, based on Mr. Mosier's testimony and the transcript, is CyberCheck is a proprietary software that essentially is made up of 1 million lines of code, coupled with, I think he testified, 740 algorithms. And Mr. Mosier testified that there is an ask from the police department. That ask goes directly into the CyberCheck software. And then in this case, 15 days later, the CyberCheck software spit out a report that said Mr. Rankin was at the scene of the crime with an accuracy rating. Mr. Mosier also testified that during that 15-day process, there are no human eyes on the software at all. It's completely automated. He also testified that his software does not collect any data. These data points that you see that are in the CyberCheck report are found somewhere on the internet, whether that's the deep web, the dark web, the surface web. We don't know because CyberCheck doesn't record, clone, duplicate, screenshot, or copy any of those data points. And this is the problem that we presented to the court. My experts cannot replicate or reproduce this report because we have no idea where these data points came from. Did they come from a private, secure location? Did they come from breached data that was leaked onto the dark web? We don't know, and we'll never be able to find out.
Counsel, but it
Yes.
seems like maybe you're arguing a data point. In other words, obviously, anytime it's better to have the source information, to have proprietary information or whatever. It's not always available, but you can still attack the admission and say it's, not reliable, it's not, scientifically accepted. And it seems like the arguments you're making already say that. So why can't we just have a Daubert hearing and determine one way or the other?
Because without the proprietary software, we couldn't formally prepare for a Daubert hearing. That's what we had presented to Judge Rowlands. And I think that's also supported by Mr. Mosier's testimony. What he testified is, look, you could recreate this. You could recreate my report, and here's how you do it. And he testified before Judge Rowlands that if you put 50 people, locked them in a room together, and gave them 30 days, they could come up with my report. Now, he also testified in the Medid case that if you took 1,000 people, not just people, but trained analysts in the deep web, the dark web, and the surface web, and you locked them in a room for 30 days, they could replicate these results. So that's why the Daubert hearing, we needed this proprietary software to even get to the Daubert hearing.
Well, except that it sounds like you may have a good argument just from what the things you've said right there, that maybe this is not scientifically acceptable.
Yes.
I guess I'm just not sure why we went the sanction route instead of just scheduling this for a Daubert hearing.
I think the court has discretion. The trial judge has discretion whether or not this proprietary software was reasonable and necessary for the defense to formally prepare for a Daubert hearing.
So what evidence did you present that was reasonably and scientifically necessary?
Yes. We presented argument, and I cross-examined Mr. Mosier. And based on that cross-examination and the argument and what I had indicated to the court that my experts had told me, the judge agreed with the defense and said in order to be ready for a Daubert hearing, the defense should have this proprietary software.
What, with the expert testifying, and I'll call him that expert,
Yes,
he said that it could be duplicated.
Right.
It could be replicated. And if you don't present any evidence that says it cannot without the proprietary software, how does the court make the decision that you're entitled to it?
that's an excellent question. And I think the court listened to what Mr. Mosher said after that, because what he said is, you could do this on your own. The second part was, you would need 1,000 experts in a room for 30 days to replicate it. And then he said 100 experts, and then he said 50
Well,
experts.
that seems to be going to credibility.
Well,
I'm not sure you should be looking at credibility yet, right?
Well, I think you have to, because this is what Mr. Mosher himself said you could do without the software. And there was another point in the transcript, Your Honor, where I said to Mr. Mosher, and Mr. Raley said here in his argument, the software scours just the open source part of the internet. And I said, and I asked him the question, so how do I know you didn't violate my client's constitutional rights and get private protected information from the deep web or the dark web that was leaked there illegally? And he agreed the only way we could find that out is if we had the software. So in other words, my experts could not go on the dark web and look at illegally seized material. I think they would be committing a crime. And the only way that we would know whether or not this material did in fact come from the open source, as Mr. Mosher testified, is with the software. That's Mr. Mosher's testimony. So this is why we needed the software in order to prepare for a Daubert hearing. I wanted to address now Mr. Raley's arguments here before the court, as well as in his brief about the subpoena. First, I think the timing is absolutely crucial and critical when evaluating any other remedies the court may have had. So as I set forth in my brief, Mr. Rankin was indicted on April 9, 2021. He sat in the Summit County Jail for over 2 years. Trial date was June 22nd, 2023. On May 24th, the state of Ohio, May 24, 2023, a little less than a month before trial, the state hands me this cyber check report. On that day, I filed the motion for discovery, asking for the proprietary software. That's in the record. 2 days later, I believe it was 2 days later, I filed a motion for ex parte appointment of experts, vestige, and that was granted. After not receiving a response to my motion for discovery, I filed a motion to compel. And Mr. Raley said here, you know, we didn't know what the repercussions were going to be. Mr. Mosher didn't know what the repercussions were going to be if they failed to comply. And I think that repercussions are clearly laid out. On my motion to exclude or compel, filed on June 2nd, I said if the state or Mr. Mosher refuses to comply with Mr. Rankin's discovery request, Mr. Rankin moves this court to exclude Mr. Mosher's report and any testimony related to cybercheck. So this was all laid out. We had a hearing on June 6th, and the court has that transcript. Nowhere during that transcript did the state of Ohio or Mr. Mosher say, well, we'll give it to you if you subpoena it. In fact, it was the opposite. As the court indicated, Mr. Mosher said, I'm not giving it to you. This is my bread and butter. This is how my company makes money.
Although he did have a caveat, didn't he, in his testimony, he said, I have to talk to legal.
He did, and that never happened, obviously. We know that. So we had the hearing on June 2nd. Nowhere was there any mention of, well, if you subpoena, we will give it to you. So on June 13th, the court issued its initial order. This was a two-step process. The initial order on June 13th said motion to compel is granted. Didn't say anything about the motion to exclude. Motion to compel is granted. And the state and Mr. Mosher knew what was coming next. If they didn't compel, I was going to then ask the court to exclude. So they knew what was coming. That is June 13th. Trial was set on June 22nd. The state of Ohio responded in a brief the next day on June 14th. And they didn't say in their brief, well, Mr. Malarsic didn't subpoena this, and had he subpoenaed it, he would have gotten it. What they argued on June 14th is, well, they could replicate this. The defense could replicate this. You don't need the proprietary software to replicate it. Deny the motion. The judge waited. Judge Rollins waited until June 21st to give the state an opportunity to comply with that order, and on June 24th, when the state didn't comply, the judge excluded. And it wasn't until the notice of appeal that the state started arguing, well, there should have been a subpoena. I think that argument was waived. The state never once told the trial court, well, if this information was properly subpoenaed, you would have got it. That came up in the notice of appeal, and it came up before this court. It was not raised at the trial court below. And what's also important is the timing. There was no room for a continuance. These motions were coming quickly, the motion to compel, the hearing. We literally got the order the day before the trial. So the subpoena argument was waived. There was no opportunity to continue this matter because the trial was starting within 24 hours. And it, I think, would have been an absolute moot point, because when Mr. Mosier testifies, I'm not turning over this information, and there's a court order that says turn it over or you are going to be excluded, I think his position was also clear.
Counsel, I'm trying to figure out how the state can, because there wasn't a subpoena, whether it's waived or not, there wasn't a subpoena. So this was just usual discovery, Rule 16 discovery between the state and the defense. And the defense is saying, give me this proprietary software. And that's a little different than the BCI cases and all these other cases where they're public entities, governmental entities that's supported by taxpayers' funds. This is a private entity. What is your argument? I guess I'm not understanding. What is your argument that the state could do that, could force this individual to give up, as he said, his bread and butter?
Well, I don't think that those were the only choices. And the transcript is clear. There was discussion about a protective order. And I think that is another remedy that the court considered and could have worked in this case. But Mr. Mosier was clear, no, even under a protection order, I am not providing this information. So that was an issue, Your Honor. But to answer the court's question directly, and I think we heard it here from Judge Hensel, the question is reasonably available to the state. And obviously, Your Honor, the state produced Mr. Mosier at the hearing on June 6, 2023. I didn't subpoena him. The state had him participate virtually. The state also had Mr. Mosier produce answers to my specific discovery requests. So it's not like the state was completely powerless over Mr. Mosier. They were able to produce what Mr. Mosier wanted to give them.
And that's what they argued, didn't they, to the court? They
Well,
said, we've done everything we can do. We've answered your request. We've brought in our expert and made him available for cross-examination so that there's an understanding of why this is not going to be turned over, or can't be turned over by the state. So what more really could they have done?
Well, I think they could have ordered Mr. Mosier to provide it or subpoenaed it, as the court indicated. Now, I think this goes to the trial judge's analysis, and what you're offering is a reasonable, valid option, but we have an abuse of discretion standard here. So I think the judge knew that she could have done that. She could have said, well, okay, we don't think that the state has any availability to get this information, so we're going to continue it. Or Mr. Milarczyk issue a subpoena. The judge, in her discretion, after hearing the testimony, after reading the briefs, felt that additional information was necessary to ensure Mr. Rankin's due process rights. And the judge felt that this information was reasonably available to the state. And I think that was a reasonable conclusion.
Counsel, when you're talking about abuse of discretion, can we look at the fact, I should say, I guess, can we look at the fact in determining whether she reasonably exercised her discretion, the fact that she did do her own independent research and then said, you know, here's the sites I looked at, here's this, there's no way this could happen. Respectfully, that's not something a judge can do.
I agree with you. And Judge Rowland shouldn't have done that. That's the short answer. Yes, you should look at that. But you should also, I would respectfully submit, look at what Judge Rowland said about that. And what she said is, look, I'm not an expert and I know that. But if you read Mr. Mosier's testimony, he was begging everyone to do what Judge Rowland did. He was saying anybody could do this. Go ahead and try it. It's open source. It's Google. If you do this, you'll get this result. So I think Judge Rowland was taking him up on that offer. I don't think that that weighed into her decision to grant the motion to compel. I think it was essentially dicta in the opinion. And even if you take that analysis out of her opinion, I still believe her opinion is sound, and she came to the right conclusion that without this proprietary software, we're not gonna force the defense to find 1,000 experts, put them in a room for 30 days alone, and have them try to replicate Mr. Mosher's report.
But yeah, you're down about 45 seconds.
Yes, thank you. Any other questions for the court? Otherwise, I am concluding.
No.
Thank you.
Thank you, Judge.
Okay. What happened there?
I just want to jump off on the last point that I just heard about the independent research. That independent research took up most of that judgment entry. I think it's hard to separate that out from the final conclusion that was being made. So I just want to put that before the court. I also want to just address generally the timing of the report's production. The report was only asked and produced after the defendant's statement had been suppressed. In that statement, he had indicated he had been at the murder scene. That occurred after years of litigation by the defense. So the delays in this case are because of that litigation, because the prior trial counsel withdrew from the case, because there are multiple trial dates moved at the court's request and at the defense request. So to have the state bear the brunt of all those decisions in this very important evidence would be inappropriate. And I do want to say that hearing Mr. Malarsik's arguments, he refers constantly to Mr. Mosher's position, Mr. Mosher's technology. It's Mr. Mosher's proprietary information. It's his company's proprietary technology. Again, if the state had it, it would have been produced. We did everything we could. As Judge Carr's questioning led to, he was offered at a hearing, which I don't even know why he had. He didn't have to be there for a discovery hearing. Everything else that was requested that the state could get from him was provided. If we had it, it would have been produced. And although judges do have discretion under the rules of discovery, they can't change the language of the rules of discovery. And here, we only have to produce what we have and what's reasonably available to us. The judge can't rewrite that and decide based on a feeling of due process that this is what we're going to expand the language to mean. So on all of those grounds, I think a reversal is very appropriate. In my last 3 minutes, I do want to address two quick items I think it's important for this court to address too. While this appeal was pending, the trial court conducted an evidentiary hearing, even though it had no jurisdiction to do so. It received additional materials that post-date the filing of the notice of appeal. That was all in flagrant violation of Appellate Rule 9, and I think this court has to offer that guidance to courts that that was inappropriate. I also want to point out the jurisdiction of this court. So the state filed this as an appeal as a matter of right under Rule 12K, because it's an order excluding evidence, and we also moved for leave in the alternative, which this court has granted provisionally. If this court decides that this has to be by leave of court, and I cited in my motion for leave this Heil case, this court previously issued, if it goes down that path, I think this court has to retain jurisdiction under that leave. There's the Carr case pending right now before this court next month, also on this same discovery issue. These cases are pending throughout the common police court. The courts need guidance from this court. So I'd ask that you keep it and not dismiss it if you decide to go down that path. So if there aren't any questions, I'd ask that you reverse the trial court's order and send it back for there to be a Daubert hearing.
Counsel, I am aware of the fact, obviously, that the trial court did conduct a hearing after the notice of appeal, but is that all offered, was that supplemented in the record?
She decided to supplement it, yes. I think that was,
I couldn't remember about that. Okay.
she decided to supplement the record with all of those materials, again, that post-date the filing of the notice of appeal.
Thank you.
See no further questions. Thank you. And thank you both for your presentations today. The court will take the matter under advisement, issue a decision in due course. The clerk will mail a copy of that decision to you when it is released, and the opinions are also available on the High Supreme Court website. Having said that, this is our last case today. The court is now adjourned until